Welcome to this edition of Persecution Report, a podcast dedicated to uncovering the truth behind the current situations in Bangladesh. I'm Professor Bidit Day. Today, we will take you through a discussion on a very important issue. International Crimes Tribunal, ICT, which has already created a lot of controversy, widespread controversy in Bangladesh and beyond. To discuss this important issue, we have a panel of experts today. We have Barrister Taposh Kanti Bol, former prosecutor, International Crimes Tribunal Bangladesh, and Senior Associate of South Asian Democratic Foundation. And also we have Dr. Masum Billah, Professor of Law, Jagannath University, and Senior Fellow at Côte d'Azur University, Nice, France. We also have Mr. Anwar Shadat Jihan as co-host today. He is a columnist and an aerospace engineer. Without any further ado, I would like to start this discussion by asking and requesting Barrister Bol to take us through the background of this crisis or the situation, how ICT started and how it has been revived and why it has been revived by Mohammed Yunus. Over to you, Barrister Bol.
Thank you. We are at a historical juncture when we are seeing that an important jurisprudential figure like International Crimes Tribunal is being misused. Let me first start with that why it was created. In 1973, this act was enacted under the guidance and direction of Father of the Nation, Bangabandhu Sheikh Mujibur Rahman. And why it was enacted in 1973? Because international crimes, what is the definition of international crimes? Is that crimes against humanity, genocide, crimes against war, and crimes against international norms are recognized as international crimes. In 1971, during the liberation war of Bangladesh, Pakistan Army and its Rajakar, Al-Badr al-Sams, which was mostly comprised of the leaders and members of Jamaati Islami, Nizami Islami, and other right-wing Islamist political parties who supported the concept of Pakistan rather than supporting the independence of Bangladesh. So to try these perpetrators, mainly the Pakistan Army members in 1973, Bangabandhu Sheikh Mujibur Rahman and the parliament of that time, they enacted this law. At first, under the Bangabandhu's idea was to try the local perpetrators under Dala line or, and the principal offenders or the Pakistan armies under this International Crimes Tribunals Act. We all know that on the 15th of August, Bangabandhu Sheikh Mujibur Rahman and his family was brutally murdered. And after that, when Ziaur Rahman take over the power, he actually abolished the Dala Line or the Local Collaborators Act. He just abolished that, but he kept that International Crimes Tribunal Act. So when in 2008 election, Awami League took this issue into their manifesto that if they come into power, they will try these local perpetrators of Rajakar, Peace Committee, Al-Badr, Al-Sams. They will try them, and they will try them under International Crimes Tribunals Act. That's why, as soon as they came into power, they amended this. So one thing you have to understand that in that parliament where this International Crimes Tribunal Act was Crimes Tribunal Act was amended, BNP was a member of that parliament. So actually, these amendment took place unanimously without any objection, and there was open debate and discussion about the necessity of the change so that local perpetrators can also be tried under this act. And that's how it all started in 2009. And within 2024 August, more than 50 judgments were pronounced against those perpetrators who committed international crimes like crimes against humanity, genocide back in 1971. If you read the debate of, that before enacting any act, there is a debate in the parliament. So if you read the debate in the parliament when this act was enacted in 1973, you will see the main purpose of this act was to try the perpetrators of 1971 War of Liberation who committed international crimes at that time. There was no purpose. There was no purpose. So, but since this was not specifically mentioned in the long title of the act, so there was this gap. But whenever there is a need to know the main objective of this enactment, we have to always go back to this debate, that why, who created this act, why they created it. So now, after what happened in 2004, by 24 August, 5th of August, as soon as the uh, as soon as the Awami League government fell, uh, what happened was that there was enormous pressure on the prosecutors. I mean, when I was a prosecutor of at that time as well, there was enormous pressure on us to resign or to lose our life even. So and in within with overnight, like even on 6th of August, it was not possible to go to the office and to to save and preserve the necessary documents of the ongoing trials. So what happened that in that situation we had to resign. We were forced to resign, and all of us resigned within 14th of August. So, and after that, you see that there was no justice, there was no prosecutor, nothing was going on, and all on a sudden it was revived. And by whom they revived? Yunus government. Yunus government actually only found all the lawyers of Jamaati Islami, all the lawyers who were actually defense lawyers earlier. They were provided that chance to become prosecutors so that they can take their revenge, nothing else. And the judges, those who were appointed, first of all, they never had any experience to tackle or to preside over any trial on international crimes. Let alone, if you look into their background, you will see that the first three judges who were appointed, the chairman, he had a madrasa background, a BNP Jamaati political background back in his student days. Then he became a judge. He retired long ago, and then he was revived again. And other judge, he was an active politician, politician of BNP, and that's why how he was appointed there. So and the other judge, he also had that, and every single judge who was appointed, if you go into their background, you will find this. So now coming to the question that why it was revived. It was revived as a revenge mechanism. There is no justice per se in the revival of this International Crimes Tribunal. Their target is Sheikh Hasina. Their target is the senior leaders of Awami League and its alliances. You see, Jashod leaders are there, Workers' Party leaders are there. All of them are getting tried. And now, uh, being said that the main reason for revival is revenge, and revenge. There is no justice.
Thanks, Barrister Ball. That's serious. Those are very serious and concerning allegations. So what you are saying is that it's about political retribution rather than upholding justice. And also, you brought kind of the context that the original act was designed to try the massive genocide, which actually constitutes the characteristic, the nation building for Bangladesh. We are all kind of proud of what we achieved in 1971. And by no means what happened in July, August 2024 could be put in the same bracket or even nearer to that. So, and that is also, the formation is not proportional and logical. And at the same time, you have mentioned about the politicization of the of the court. Dr. Bill, would you like to add something to that, please?
Thank you very much. Thank you very much, Professor Bedit, and my co-discussion, Barrister Taposh Kanti Ball and Jian. I cannot agree more. And this is a very serious allegation. I concur with Barrister Ball that a kind of revenge mechanism is on play. And I would like to add that this is not only a revenge mechanism, but also a serious abuse of justice process. Let me tell you why. It has been just over a year or so, and you are standing that one of the brightest prime ministers of Bangladesh is on the verge of giving the highest sentence. It has taken place just over a year,
And longest serving as well.
and longest serving as well. Now, look at the example of ICC, International Criminal Court. Since its inception in 2002, up to now, it has delivered at best 4 to 5 judgments in 25 years of its history. Look at the Bangabandhu murder case itself. Look at the fate and history of Sheikh Hasina herself. She was one of the greatest victims of human rights violations in the history of Bangladesh. Her father, the founding father of Bangladesh, Bangabandhu, was assassinated along with the family members. And the indemnity ordinance was promulgated and was made a part of the constitution. It was 21 years to initiate the case in 1996. So Sheikh Hasina herself had to wait 36 years to have justice for the assassination of her father. Even look at the history of the International Crimes Tribunal Bangladesh. It has 3 phases. 1973, which was not actually acted upon through the intervention of international players. The Complementary Collaborators Act was nullified. That was the first stage. Second stage, which Barrister Ball has just mentioned, in 2009, through the approval of the parliament. But it took almost 10 to 15 years to hand down all these judgments, right? Now, at the third stage in 2024, within this 1 year, it has been amended 4 times. Can you imagine it? And just over a year now, they are going to hand down this so speedy that itself tantamounts to abuse of justice process. Now, look at this tribunal. Once upon a time, we say that the International Crimes Tribunal is a matter of pride. It has long yet glorious history, because Bangladesh was the first country to enact such kind of law. Domestically try the perpetrators of international crimes. And even the international community enacted the Rome Statute in 1998, far after than Bangladesh. So Bangladesh set a greatest example as a manifestation of its erga omnes responsibility, of its just causes responsibility, peremptory obligation to try all those perpetrators of atrocities and genocide and crimes against humanity committed during the 1971. Now, the tribunal you are watching today is not the same tribunal. So the whole framework has been changed, being politically motivated. So we are saying that this tribunal has changed and designed to targetedly to bring all the political leaders of Awami League, including Sheikh Hasina, into to the justice. But this is a sheer travesty to justice being politically motivated. I give you one example. The judge which I just mentioned, he was appointed unconstitutionally. Just Article 98 of Bangladesh Constitution was used as a camouflage to champion his appointment. He was appointed as an additional judge, but the ICT Act 1973, it says to be the judge of the or the chairman of the International Crimes Tribunal, one must be a judge, full confirmed judge, as the act itself says. But Article 98, it says additional judge. So an additional judge, temporarily appointed, not confirmed yet, serving his probationary period, was simply posted to the ICT in order to obtain this kind of verdict. So this is completely a politically motivated tribunal, and the judgment tomorrow is going to be delivered can easily be perceived that it is going to be the foregone conclusion. I perhaps you have watched that already. The state-owned Bangladesh Television has taken all kind of action to lively broadcasted, meaning that the government machinery and all other actors supporting this tribunal, they know what will be the outcome. If not, the capital punishment is sentenced, is handed down. If they hand down a life sentence, they will stage a kind of anti-Shahbag demonstration in order to enable the state to hand down the capital sentence. So all and everything is set to hand down a politically motivated judgment. So I regard it as a complete abuse of the justice system.
Thank you very much, Dr. Bila. That's again very insightful. Barrister Ball, do you see that there is also, we talked about political vendetta, but also political witch hunting, that this tribunal is being used to eliminate Awami League and progressive political parties from Bangladesh?
There is no doubt that that is the main focus of the present trials. Look, our Prime Minister Sheikh Hasina, she said that this is a kangaroo court. Now, and this kangaroo court is targeting not only Awami League persons, not only Awami League leaders. It is targeting, if you are a believer of secularism, if you believe in the high ideals of 1971, then definitely you are a target of this tribunal. You don't have to have any other qualification. Now, why Prime Minister Sheikh Hasina, she said that this is a kangaroo tribunal? First of all, and how do you know that this is targeting Awami League leaders and those who believe in the high ideals of 1971? First of all, look into the appointments, the investigators, the judges, the prosecutors. Every single one of them, they don't believe in 1971, or they don't believe in the high ideals of 1971. After 5th of
Sorry, Barrister, sorry to interrupt you. Just for the sake of our international audience, when we say high ideals of 1971, we allude to pluralistic, equitable, and democratic and secular Bangladesh.
Thank you. Thank you for the clarification. I should have mentioned that as well. But what I'm saying is that if you look into the appointments, you will find that that they don't believe in the high ideals of 1971. Number one, they have this anti-Awami League, attitude or belief. You can find it from their social media platforms they used before their appointment, and even after their appointment, they are using them. So you will find it very clearly from there. Then you will find that till today, after their appointment, they haven't uttered one single sentence regarding the 1971 War of Liberation in support of that they believe in it, or they're paying any respect to the martyrs, to the Birangonas. You will not find anything like that. Now, that is one perspective. For example, let me give examples from the appointment of the prosecution. Look at chief prosecutor. Before getting appointed, number one, he was a defense lawyer of Jamaat senior leaders. Number two, he is one of the leaders of AB party, Amar Bangladesh party, which is again a subdivision of Jamaat Islami. Right now, let us if you look into his actions, you will see that he is always the time supporting those who are from Jamaat Islami, who are right wing terrorists. He is always the time supporting them. Even after being appointed as the chief prosecutor, he participated in processions against Awami League, which he cannot, because then this is conflict of interest. Right now, even after that, he was repeatedly criticizing the Awami League government, the liberation war, and as I said, not only him. If you look into other prosecutors, they have the same biodata, and their social media has the same thing. One prosecutor they put up as the as the digital evidence analyst, right, Mr. Zoha. So Mr. Zoha, he claims that in 2016 he was abducted by the government, right, by the then Awami League government. Now you are claiming that you are a victim by the very leaders, and after that you are claiming that you are a prosecutor of the same trial of those persons whom you personally accused. You cannot. So this is the same thing, because if you look recently in Philippines, former President Duterte, in his trial before the International Criminal Court, his lawyers applied that the prosecutor of ICC, Mr. Karim Khan, he cannot be a part of that trial. And because why he cannot be a part of the trial? Because earlier he represented the victims of Duterte, of Duterte's actions, who claims that they are victim due to Duterte's decision as a president. He supported those victims. So there is a conflict of interest, because a prosecutor cannot just say that this person is accused and I will ensure that he gets the highest punishment. Prosecutor cannot have this kind of mentality, because prosecution is a government post, is a public post. You must have that neutrality. The moment you lose that, the moment you lose that principle, no, that presumption of innocence, presumption of innocence is, Dr. Billa will agree with me that presumption of innocence is the core of criminal justice process. If you, the moment you lose it as a judge, as a prosecutor, as an investigator, you cannot do anything which shows that you don't believe in this principle. The moment it shows, the moment you lose all sorts of footing. So that there goes the appointment process, and so that's why they cannot do it. Now look into, let me show you that they are targeting anyone and everyone who went against Jamaat Islami. Look into the case of Hasanul Haq Inu. Why Hasanul Haq Inu was targeted? Because he was persistently against Jamaat and its policy. So that's why Hasanul Haq Inu was made target. There is no real allegation against him. Likewise, there is no real allegation, real evidence against Sheikh Hasina as well. Now, this judgment is predetermined. Take a note out of it. We all know that that court will announce highest punishment to Prime Minister Sheikh Hasina and other senior leaders. There is not going to be any alternative to that. Now, how do we know that? We know it because the law advisor, back in August, September, he said that by October 2025, we will have judgment against them. That is, I quote and unquote this law advisor. That is what he said. So when the law advisor says that, and then you just delivered that, and you get the reward. Dr. Billa recently wrote a wonderful status on his Facebook saying that these judges got permanent the other day. Why? They got their prize,
They're rewarded.
a reward before they got delivered this judgment. That is the most important thing, because before that we were saying that these guys were not permanent judges of the High Court division. So they will deliver any judgment to confirm their position. So you cannot make any temporary judge deliver a judgment like this. So that's why you are giving the reward. You are saying, okay, you delivered this judgment, your reward is confirmed. That is another thing. So we know always that, and even the chief prosecutor, Mr. Tajul, on more than occasions in front of the camera, he said that these the Prime Minister Sheikh Hasina and the senior leaders of Awami League will be punished. Now, let me tell you that the kind of lawyer who was appointed for Sheikh Hasina, na? The kind of lawyer who even off camera suddenly said that he also doesn't believe in her innocence. And he is just doing this as a part of his act before the court. So these kind of lawyers are appointed. And when senior advocates like Advocate Jedai Khan Panna requested that they be appointed as her lawyer, state defense lawyer, their application is turned down. So, I mean, and another thing that what Dr. Billah also said, that look at the speed of delivering the judgment. Look at the speed trial is getting to end. In Bangladesh, if a criminal trial starts of a murder case or of a rape case, as a practicing lawyer, I can tell you that it will take at least 6 to 7 years to conclude a trial. In our tribunal, even when I was a prosecutor, at least a case, it took at least 2 years, 1.5 to 2 years to finish a trial. A trial, not investigation. Investigation took another 1 year, because there has to be some sort of document collection, statement collection, and then you have to go back and confirm those facts. Now, I will conclude just by saying that if you look into the quality of the evidence produced against Sheikh Hasina, you will see that all the evidences are hearsay evidences. Number one. Number two, all the witnesses are interested witnesses. The only witness who claimed to have heard or seen something is the former Inspector General of Police, who is also a co-accused in this case. Now, he has become an approver witness, right? Or we, in some jurisprudence, we call them insider witness. So before agreeing to become an approver witness or insider witness, for more than 100 days, he was kept in police custody in the name of remand. Right? So think about the trauma this person went through, the kind of mental pressure he put into. And he is a 60 plus guy, isn't it? So how much pressure he can sustain? So at the end of the day, he gave in probably, and then he has given the witness what he is giving. So without any evidence, without any witness, this kangaroo tribunal, this kangaroo trial is just giving a already written judgment prescribed by Dr. Yunus and his associates.
Thank you, Barrister Boli. You mentioned about witnesses being coerced, and also a lot of assertions being made on the basis of hearsay. The way, the speed that resulted to the verdict to be handed down. These all are questionable, and we have reasons to believe that these are not fairly and duly processed. So there are serious questions about the tribunal. Dr. Billah, may I come to you for just briefly before we'll have a look at a clip which will actually support what Barrister Ball said. So we are missing the big elephant in the room, and that's about Muhammad Yunus and his government. So we see that the trial is politically motivated. But where does the government stand? I mean, Barrister Ball mentioned about Mr. Asif Nazrul being the law advisor, but where does Muhammad Yunus, as the head of state, stay in the whole dynamics? Does he have any vested interest as well?
Why not? If you can escape yourself from the serious allegations of labor law violations, look at the history. He assumed power on 8th August 2024, 3 days after the so-called revolution. But he was to go to jail on 5th. So this revolution, in a curious way, has saved him from going to jail. And can you remember that he himself conceded the judgment of the High Court division, where he himself submitted and deposited the punishment money to the court, about 1,200 crores tax evasion. So this assumption of power, this opportunity, has actually helped him in many meaningful ways to save him from going to jail. So there is every kind of vested interest. If you ignore all the international activities and his linkages to other international networks and being an aid to this plot of political change. So I would say that the present Yunus administration, individually and collectively, is aiding to this justice abusing process. That's number one. Second, for a quick note, in addition to Barrister Ball, look, the amendment to the 1973 statute made in 2024 is seriously objectionable, seriously open to challenge, because it has been done by executive ordinance. As per the Constitution of Bangladesh, any ordinance need to be passed by the parliament when it is introduced after its assumption, after its reopening. Now, for the sake of argument, let us say that under the amended law, a judgment has been handed down and has been acted upon. But the reconstituted parliament in 2026 did not approve that. What will be the fate of this action? This is non-fractious. This is without any jurisdiction. This is mala-fide. This is coram non judice. So at any parlance of law, either national or international, the ongoing justice process is objectionable and questionable.
And also, he is very much relying on Jamaat-e-Islami and other right-wing Islamist parties who have got this political vendetta against Awami League. So, can we also suggest that Muhammad Yunus would be very keen to appease those right-wing parties to perpetuate his stay in the power, and that's why he is also expediting this particular verdict so that he can somehow garner more support from those quarters.
Absolutely, because that's his also an opportunity to show, look, I'm arranging this kind of trial, so he needs popularity because over the 1 year he has already lost the ground. So in order to fortify and consolidate his place, again he will be trying to show that, look, I have done some kind of judgment, so I will do it if you allow me to be in power. So again, this is designed to save him from any further immediate repercussions.
Thanks, Dr. Bill. I can see that Mr. Jihan has actually dropped out of the call, so we can continue our conversation. I will go back to Barrister Ball. Mr. Jihan is back. Mr. Jihan, can you hear us?
Yes, can you hear me?
Yes. We can hear you. So when you're ready, you can present some of the evidence which clearly shows that there are serious concerns about the neutrality and objectivity of the prosecution.
Thank you, Professor De. Sorry, I had some issue with the internet. So we are talking about a kangaroo court, a circus show, if you will, that they are orchestrating. So let me first show you guys a video clip where you will see how the state-appointed so-called defense attorney is claiming openly in court that he has been acting as a parrot in front of media just to prove, just to show that this judicial process has any credibility. So let me play the video for you.
না, খালাস পাবে তা বলে না। আমি বলছি যে আমি বিশ্বাস করি, যখন সাংবাদিকরা প্রশ্ন করে আমাকে যে আপনার আসামি খালাস পাবে কিনা, আমি বলেছি আমি বিশ্বাস করি যে আমার দৃঢ় বিশ্বাস যে আমার আসামি খালাস পাবে। সেটা তো বলতেই পারি আমি, আমার বিশ্বাস, আমার চেষ্টা, সে জায়গাটা আমি বলতেই পারি। যদি ভুল হয় আমার আদালত আমাকে সংশোধন করবেন। তাছাড়া আমার না বলে উপায় কি? আমি যদি বলতে আমার আসামি খালাস পাবে না, তাহলে তো মানে জাতি এবং মাননীয় আদালত লর্ডশিপও বলবেন যে কেমন লয়ার আমি স্টেট ডিফেন্সে নিয়োগ দিয়েছি যে আসামির ফাঁসি চাই। তাহলে তো এটা আরো খারাপ, আপনার জন্য খারাপ, আমার জন্য খারাপ।
As you can see, as if it is a comedy show, he is openly claiming that he has been acting just to show that this process has any credibility. So he has been lying that he believed that his defendant will be acquitted just to mimic a credibility. And this is the situation when, it is pretty normal to have this situation, because if we look at what the law advisor, the so-called illegal law advisor, Mr. Asif Nazrul, said back probably in February or sometimes back then, that the crime allegedly committed by Sheikh Hasina surpasses the extremity of those atrocities of 1971. Can you imagine the gravity of this sentence? It is a direct insult to the memory of the 3 million innocent Bangladeshis that were killed, more than 200,000 women that were raped. The law advisor is openly insulting their memory. And rightly Barrister Ball and Professor Billa mentioned about the Chief Prosecutor Tajul, who is a active member of the AB party. And we have seen meeting of AB party Tajul with the NDI IRI team. That also had some play in the July massacre. And then even recently now, when he is holding the position of the chief prosecutor, he is participating in procession of the AB party, which is beyond any normalcy. And then the so-called Attorney General, he is teaching us some new law that he can participate in election while holding his post as an Attorney General, as if it means nothing. So as we are seeing that the whole judiciary of Bangladesh has been converted into a mockery, a circus show, and the verdict that will be delivered tomorrow means nothing in a democracy. It means nothing in a competent criminal court, and most importantly, it means nothing in the millions of the minds of Bangladeshi people who were misled last year. Back to you, Professor De.
Thank you, Mr. Jihan. So we already have talked about that that appointment of the prosecutors as well as the defense lawyers, and that particular 1-minute clip serves as a clear illustration of how the defense lawyer is doing their duty. Barrister Ball, you served in the previous ICT. In terms of professionalism, in terms of integrity, in terms of objectivity of the trial process of the prosecutor team, would you like to compare, how what you experienced and you served and what we saw or being experiencing or watching right now?
When I was serving as a prosecutor, the main thing that I want to say that most of the prosecutors were not part of the ruling party. Most of us were practicing lawyers who were completely focused on trying the perpetrators who committed international crimes in 1971. That was the main goal. And the second goal, that the jurisprudence that we were creating, we wanted to teach it to the next generation so that they know that what Jamaat and other right-wing political parties did in 1971. And then they can compare as well that what Jamaat did even after the revival of their politics by Major Ziaur Rahman. So this is, in comparison, the professional level, as I said, that the time that we took for investigation, then writing the formal charge, then presenting the evidence during the trial, every single thing was quite, uh, but I mean, I would say that quite perfect to satisfy the requirement of rule of law and natural justice. Every single time we asked the accused person if they were present in the dock, that whether they can afford a lawyer. If they cannot afford a lawyer, then the court always then provided them a lawyer, and particularly a lawyer who believes in his political ideology. Even in absentia trials, the court was appointing those lawyers who are Jamaati lawyers. They became prosecutors after that, right? Prosecutor Ghazi Tamim, prosecutor Palwan, every single one of them was defense lawyers, state defense lawyers, and they became prosecutors. So what I'm
And
trying to
also, if
say,
I'm not mistaken, they are also assisted and counseled by internationally acclaimed overseas lawyers like Toby Cadman.
yeah, they were. I was
They
coming
were
to
given
that
that
point that
opportunity.
even
Yeah.
he was appointed as the special advisor to the chief prosecutor on this trial. This person, he was a paid lawyer of Jamaat Islam. So he was paid lawyer of the accused persons who was living abroad and denying the trial at the time. So again, they have no neutrality. The principle of, as I said, rule of law and natural justice requires that you cannot have any conflict of interest. The moment you have any sort of conflict of interest, you lose the footing to participate in any trial in whatsoever manner. Even look into the Constitution of Bangladesh. In the Constitution of Bangladesh, Article 31, 32 categorically says that if you want to punish anyone, if you want to try anyone, it has to be as per rule of law and natural justice. I'm not quoting word by word, but that is the essence of those articles. And law has to be applied equally. Unfortunately, the law is not being applied equally. That is the interesting bit, because you look, the constitution is still in force. In the constitution, it is said that how a law has to be amended when the parliament is not in session, and for how many days. Dr. Billah has rightly said the way they are enacting everything through ordinance has already become infractuous, and the government is ultra vires completely, while they do not have the jurisdiction to make these amendments because the parliament is not in session and will not be in session even within the requirement of the constitution, right? So that's why they are now forcing upon the people the July Declaration. There is another customary law that the previous parliament cannot do any cannot pass any law which will bind the next future parliament, but they are trying to do with this July Declaration, right? They are saying that even if you don't pass it or discuss it, after 200 and so many days it will automatically become a law which is superior to the constitution. What an audacity. So coming back to this, tribunal again, look, in this tribunal, through this one illegal amendment, they have introduced digital evidence, right? That digital evidence can be presented before this court. And what they have done, they have produced all video clips they have collected from social media. Now, International Bar Association and International Criminal Court, and even the the British law and the USA law, if you follow, you will see that there are very concrete set of rules which says that when you can and how you can submit digital evidence. Because in the legal language, we say that every single piece of evidence has to have a probative value. Now, in this era of digital science, you can manipulate any sort of video, right? You can make, like, you can capture my face and you can make me say any word that you want me to say. For this reason, International Bar Association and International Criminal Court, they have said that from the very moment of creation of a video or an audio on the digital world, you have to disclose who have created it, who has recorded it, on which date, on which year. The timeline is very important. You call it timestamp, right, Jihan bhai? So there has to be a timestamp on a video that has to be disclosed. Who recorded it has to be disclosed, and after recording, with whom you are depositing it. It is very crucial because, for example, you recorded a video and then this video will be used in the International Crimes Tribunal of Bangladesh. Then an investigation officer collects it. In what format he saves it, that is very important. MP3 or MP4 or whatever format. This is, and this chain of custody, because a person creates it, then one person saves it, investigator collects it, then it goes to the prosecutor, then they displays it. So this chain of custody has to be very clear in front of us. In none of this evidence, they presented this chain of custody. In none of these videos, whoever created these videos or recorded these videos, they were presented before the tribunal so that the defense lawyer can ask them questions.
Also, I have a question, Barrister Ball.
Yes.
The defendant has a right to examine these evidences, right? Like they have the right to examine these evidences and have ample time in doing so, which the defendant did not have in this case.
In any of the cases before the tribunal, it's very interesting. Again, I will go back to my prosecution days, that we remember that we used to give CDs of all the digital evidences to the defense team so that they can examine anything and everything, because we didn't have anything to hide. We were trying the perpetrators of 1971, but here they are not giving these digital evidences to the defense lawyers. They had to ask for it.
So
They are
to
not giving it
summarize,
automatically.
can we say, Barrister Ball, that Sheikh Hasina and other accused didn't have enough opportunity and legal ground to defend themselves in a proper way to an international,
Yes.
up to the international requirements? Yeah.
Absolutely. At first, I said that how they have appointed the state defense lawyer, number one. Number two, they did not serve this notice of this trial to her directly. They failed. And number three is that they did not give the opportunity because of a lawyer of her own choosing to ask these questions. So and look at the situation of the country. Prime Minister Sheikh Hasina, she just told the other day in an interview as well, that with Anandobajar Potrika, that if she didn't leave the country, her security would have been compromised, she would have been killed, and there was a situation that a civil war could have broken out in Bangladesh, and many more people could have died, isn't it? So in that situation, look how generous she is, that she put herself out of the situation so that the situation can calm down. So this is how a political leader should be. But what is the situation in Bangladesh now? If she goes back to participate in the trial, even if she is not killed by the mob, she will be harassed in the open court by the mob. She might be killed in the prison, because already more than 25 Awami League leaders are killed through negligence, through probably poisoning, because our young leader Sabir, after coming out of prison, she said that she found certain poisonous things in her blood. So probably she would have been killed by poisoning. So all sorts of situation we have to take into consideration. Up to you, Dr. Dey.
Thanks, Barrister Ball. Dr. Billah, where does it take us? Where does it take Bangladesh, its judiciary, and the future of democracy?
Very concerning. And I tell you, it's not only Sheikh Hasina has been put on trial. It is Bangladesh's founding values, Bangladesh's history is put on trial. And tomorrow will be a watershed in a bad sense in the history of Bangladesh. And I apprehend that the law and order situation will deteriorate. And once the judgment unacceptable, illegal, unacceptable to international criminal law standard will be delivered, the fate of Bangladesh will be precarious, will be deteriorated further. And I'm afraid that there will be different groups within the state, within the country, fighting each other. That will take Bangladesh to a path of uncertainty. That's a note of caution from my part. Now, adding to some more points with Barrister Ball. Now, let us be very practical, Professor Dey. It's easily can be noted that there were huge deaths, widespread atrocities during 2024 July uprising. There were incidents of deaths. Now, if a prime minister or a person sitting at the apex position of the government needs to take criminal responsibility, what is logical deduction. The logical deduction is all the deaths taking place after 5th August during Yunus administration. Professor Yunus should also take criminal responsibility. This is a logical deduction. But we need to cautiously distinguish between accountability and criminal responsibility. As a law academic, I will be interested to see how the prosecution has proved the criminal attribution of criminal responsibility towards the prime minister. Because today, if you look at the papers of Bangladesh, one of the police commissioners has said, Sajjad Ali, has said that if you found somebody arsoning, fire them, shoot them, and the criminal law permits it. If that is the case, draw a logical conclusion. During the 2024 July uprising, it is the criminal law of the state that says you. That
it was
says
more of a riot than uprising.
Right.
It
is not the manner of commanding by a prime minister. So there is a huge gap between the prime minister's position and the field level chaotic situation. The issue is whether the law enforcing agency in a mob rioting situation has applied proportionate or disproportionate force. If it is a disproportionate force, there was a violation of human rights. But as a general sweeping conclusion, you cannot draw that conclusion that the prime minister is criminally responsible for quote and unquote crimes against humanity. This is a serious kind of violation of law.
Yeah.
Right, that's number one. Number two, that look, the appointing authority, Professor Asif Nazrul is giving you the suggestion, is giving you the message, conveying the message to the judges that the commission of crime during the July Revolution is far greater than the 1971. And you are confirming their service appointment. You are rewarding them, you inducing them, which runs against established Bangalore principles of judicial ethics and integrity, and the principle recognized by the United Nations judges' accountability and independence. So you can easily point out what my reservation is. Another thing, in the Kader Molla judgment, Professor Barrister Bol might know it, in para 78, the then ICTBD judges noted that the 1973 Act is particularly applicable to try the 1971 crimes. So the scope was very much determined. Now, by the 2024 amendment, the applicability, the extent of the law has been extended in violation to the retroactive principle. They have redefined the crimes in order to bring the crimes committed after its commission. So this is a clear violation of the constitutional principles of retroactivity and also recognized by international human rights instruments called International Covenant on Civil and Political Rights. Okay,
Yeah.
so it is a violation of the nullum crimen principle, right? After commission of the offense, you are extending the area of the crime and the element of the crime. And I tell you one serious thing. This Professor Asif Nazrul, by his own volition and wisdom, has made an amendment defining crimes against humanity. Some new elements like showing to the world that they are maintaining international standard like widespread attack, systematic attack like that. At the same time, has added, if there is a inconsistency between the 1973 Act and the ICC statute, the 1973 Act standard will prevail. Now you see that they are defining crimes against humanity in a new manner, which is a clear violation of the retroactive principle. So
Thank
our
you.
reservation is on the question of due process, on the question of fairness, on the question of law, and as well as on the question of effective representation, a trial in absentia. In every respect, this is a politically motivated trial, unacceptable to any stand of international criminal law.
Thank you very much. I'm conscious of time. So, dear viewers, we have got some very valuable comments and insights from two experts in law. One, a practitioner, the other one is an eminent academic. So both of them came to the conclusion that this ICT, formed by Muhammad Yunus government, has been politically motivated and is a way to implement political agenda, to implement their vendetta against Awami League and progressive political parties and progressive political ideologies in Bangladesh. So this ICT is not just a court, as Dr. Billah very eloquently asserted, that it is trying Bangladesh as a country. This will decide and determine where Bangladesh should end up in a year time or in few years time if we do not start protesting and opposing these and all these activities and misgivings of the Yunus regime. This country will be taken to a disaster. We will meet again on another episode. Until next time, I am Professor Bidit Day, signing off. Thank you.